Resilience Levy Act 2018. Item number 2, Attorney General's Reference Constitutional Questions Bill 2018.
Mr. Speaker, honourable members, I beg to move that a bill for an act for the referral of important questions of interpretation of the Constitution and the constitutionality of legislation enacted by Parliament be read a first time.
Honourable members, the motion is a bill for an act to provide for referral of important questions of interpretation of the Constitution and the constitutionality of legislation enacted by Parliament be read for a first time. All those in favour say aye.
Aye.
All those opposed? The ayes have it.
Mr. Speaker, honourable members, I beg to move under Standing Order 48.2 that this bill be taken through all its stages at today's sitting.
Honourable members, the motion is, in keeping with Standing Order 48.2, that this bill be read through all of its stages at today's sitting. All those in favour say aye.
Aye.
All those opposed say no. The ayes have it.
Mr. Speaker, honourable members, I beg to move that a bill for an act to provide for the referral of important questions of interpretation of the Constitution and the constitutionality of legislation enacted by Parliament be read a second time.
Honourable members, the motion is a bill for an act to provide for the referral of important questions of interpretation of the Constitution and the constitutionality of legislation enacted by Parliament be read for a second time. All those in favour say aye.
Aye.
All those of a contrary opinion say no. The ayes have it. Now we proceed to debate.
Mr. Speaker, honourable members, this is a very straightforward bill, but with...
Could I get a little... I'm glad that I called the Honourable Prime Minister just before he made his comment on the...
What are you standing on?
The Prime Minister is giving way, Honourable Speaker. Thank you very much, Mr. Speaker. I know you genuinely didn't catch the eye of the Honourable Prime Minister.
Yes, I didn't.
Mr. Prime Minister, this very simple piece of legislation, as you identified, speaks to matters related to the Constitution of the state. In fact, the object and reason speaks to, this bill seeks to make provisions for constitutional.
But, honourable member, isn't that presentation which you are making now most germane to when we get to the substantive debate?
I'm addressing the Honourable Prime Minister. And I'm trying to indicate to him that the bill, as we understand this side of the House, speaks to the Constitution of St. Vincent and the Grenadines and its relationship to the Parliament. A number of people have reached us and have made representation of unease on the subject matter, and I am unease, and I'm raising with the Honourable Prime Minister whether it would not be good sense for us to refer the bill to the Bar Association, the civil society, just give it a little time for reflection. It has come to us within a relatively short notice, less than a week, so that we could make even more informed discussion on this subject matter. If it is not his view, then certainly we will engage him this evening. But if he figures that what we're saying has merit, then we...
May I add also, Mr. Speaker, that the Honourable Dr. Friday said that he had not had a chance to even study the bill, and that in keeping with what happened with the climate resilience, I myself got my package 2 days ago, and I only looked at it yesterday. So I think I have also had many calls, and I support what Honourable Sinclair is saying, that it's a bill that touches and concerns the Constitution, and that persons might need more time. I do not think it would be wise to go through all the 3 readings of the bill today without giving some more time for the public to have a look at it. Many persons didn't even know of the existence of this bill until maybe today or last night. And because of the importance of it and because it touches and concerns the highest law of the land, I also request that because of the short duration that we have had to even look at it, I have not been able to properly study it, that it be given some more time.
Mr. Speaker, this is a bill in every material particular. It's passed in St. Lucia and has been used by the Court of Appeal before. And what we are seeking to do here in this bill is to have the Honorable Attorney General make a reference to the Court of Appeal on any provision of the Constitution which may be referred by him to the Court of Appeal, and to have the Court of Appeal say whether that particular provision is constitutional or not. It doesn't address it doesn't change anything in the Constitution. What it does, it aids in the interpretation of the Constitution. This is not anything about the alteration of the Constitution. There are provisions in Section 37, as I recall it off the top of my head in the Constitution, 36, 37, dealing with the matter of the alteration of the Constitution. I don't want it to be bandied abroad that we are seeking to change anything here in the Constitution. What is being asked is for the Honorable Attorney General to, on certain matters, to refer the matters to the Court of Appeal, and for the opinion of the court, to hear and consider the reference made, to answer each question so referred, and to certify to the Attorney General its opinion on each question with the reasons for each answer. You have an Attorney General reference in the United Kingdom. There has been a lacuna in our own, an absence in our own statutory law which provides for this particular route. And Mr. Speaker, the genesis of this, you may recall, and we all agreed that we should do this. The honorable leader of the opposition, when the debate involving the no confidence motion, there was, Mr. Speaker, a suggestion by me, which the honorable leader of the opposition said, yes, it was a good suggestion to bring this particular kind of legislation. And you yourself, Mr. Speaker, when I raised the issue, you said it's a very good idea. And I suggested to you that maybe you could await the passage of this particular law before you make a ruling. And you said that you don't have to wait the passage of the law. You'll make a ruling, but you will welcome such a law. You had stated that, Mr. Speaker. As I recall, I don't know if I'm representing you correctly there, Mr. Speaker.
Well, yes. Essentially that's what we had agreed.
That's the case with the leader of the opposition also agreeing. Mr. Speaker, what I believe, and we must speak the truth, what I believe is exercising the minds of the opposition, possibly, is that there's been a recent discussion as to whether the honorable leader of the opposition, in his capacity as Godwin Friday, representative for the Northern Grenadines, whether he doesn't have an allegiance to a foreign state or power and therefore should not sit in this parliament. I don't know whether there's an apprehension on the part of the opposition that this is the purpose for this bit of legislation, to have an Attorney General reference made on it. The point about it is this, Mr. Speaker. The point is that, Mr. Speaker, we had a discussion, and this arose in a different milieu, a different question which was before us. And it is true that the Honorable Senator Batista said across, if I understood her, that somebody can bring an action if they want to test the constitutionality in respect of Dr. Friday being able to sit here. But clearly, one way, because it struck me when I hear this talk from the opposition, it struck me that it must have, at the time, well, maybe because of the agreement which we had, the understanding, maybe they're thinking that it is brought now to address the issue surrounding Dr. Friday. I wondered. So that, Mr. Speaker, I'm on my feet, you know. I'm on my feet, and there's nothing insulting about this. I am a member of this parliament, and I can articulate within the ambit of the rules of the House something. I can make a suggestion. You may reject it.
Mr. Speaker, may I on a point of order? May I on a point of order, Mr. Speaker?
Say the point.
I rise because what the Honorable Prime Minister is saying is that he knows, or he believes, that on this side we have a hidden agenda, because he said it was a lie. Let me just please finish.
No, that wasn't said.
He said we must speak the truth. I interpret it to mean that we're not speaking the truth. I think that is even a worse way of putting it than say hidden agenda.
No,
but
when he said we must speak the truth, I thought he was saying he wants to articulate the truth. I don't think he was saying that.
No, I think it was clear that he was suggesting, because he went on to say that we had a meeting and we would have decided that it has to do with Dr. Friday. That is absolutely untrue. In fact, what has been...
Mr. Speaker, is there a point of order? What is the point of order?
I am
and
making
let us deal with it.
I am making the point
first
of
all,
order.
you must, Mr. Speaker, she must state her point of order.
Articulate the point of order.
State a point of order.
I am stating
in respect of the standing orders. Please, please, please. I'm on my feet. And if she states a point of order,
yes.
And if
the honourable member,
if the honourable member states a point of order, I'm sorry, Mr. Speaker, and you agree that that is a valid point of order, you allow her to state that point of order, Mr. Speaker. The point of order is not an occasion for a debate.
So may I continue now, Mr. Speaker?
State a point of order.
I am stating on a point of order that the Honourable Prime Minister was imputing improper motives.
Honourable Senator, hold on. A point of order is not where you get up and say, I want to speak on a point of order. There's a particular, based on the standing orders, you want to make a clarification, you want...
But you didn't let me finish.
No, but I
was saying he was imputing improper motive. And I said by saying that we were not speaking the truth, yes. And went on to say that our fair, or words to that effect, is that we believe that this bill has to do with whether Dr. Friday swore allegiance to foreign power. And he went on to say that we even had a meeting, or that was our, and that is not so.
That who had a meeting? That who had a meeting?
That we on this side, no. That is our fair. And that...
Mr. Speaker, I did not say that. I said at this occasion, when we had a debate.
When we had a debate,
I didn't talk about any meeting which you had. You all are imagining things. I didn't say that you had a meeting. No. I didn't know that.
No, you were imputing.
I didn't impute that, Mr. Speaker, please. Please.
No, may I just at least finish the point that I'm making and let you rule on it?
Yes, please.
I am saying that it's nowhere in our minds, it ever entered our minds that this has anything to do with Dr. Friday, because it certainly makes no sense. If that was an issue, you don't need this bill to take the matter to the court.
Well, that's what the Prime Minister said.
The point therefore is that this is much bigger. This bill is much bigger than any issue of taking the vote of no confidence to the Court of Appeal.
Let me just say, Honourable Member, you should know, if the Court of Appeal does not engage in academics, so when we met and we had the vote of no confidence, and then that was, let me speak please, when there was the motion of no confidence, or when that discussion took place, we agreed that based on the contentious nature of that discussion and the way it was flipped from a motion of no confidence to a motion of confidence, both the Prime Minister, the Leader of the Opposition, and I said that it's a good idea for us to refer it to the Court of Appeal for an opinion. Now, you cannot tomorrow morning send a letter to the Court of Appeal and say, you know, we have a section here called Section 47.2 and we want you to comment on it. Let me finish, please. I'm not going to speak much longer. So, in order for us to do, if we are agreeing that we should do what we said we would do, in order for us to do it, we have to pass this bill.
With respect, Mr. Speaker, I disagree.
We don't have to do it?
No, you can raise the issue in the High Court. You don't have to go directly to the Court of Appeal. But the issue that we are concerned about...
But we said that we were going to go to the Court of Appeal.
This bill is bigger than that. This raises constitutional issues. This raises removal of the Privy Council behind the backs of the people. This raises the issue that if this is passed, exactly what happened in St. Lucia, because the Honourable Prime Minister referred to it, you know, the St. Lucia bill, and it raises the issue that the Privy Council can be removed behind the backs of the people.
Well, behind the backs of the people...
Without having a referendum.
No,
because that is what was decided in the case in St. Lucia, and this is our concern, that the issue is much bigger, with respect, Mr. Speaker, than just a vote of no confidence issue. It is something that could go to the root of our right to appeal to the Privy Council. And I can show you why I'm saying this based on the exact same case that the Honourable Prime Minister referred to in St. Lucia, which our Attorney General sent Richard Williams as part to represent St. Vincent. And because of that, we are saying on this side that an act that is so far-reaching should go to the Bar Association.
So now are we saying that let me try to understand clearly. Is the opposition now saying that we should no longer proceed with getting an interpretation from the Court of Appeal on the issue?
We are not saying, we are saying that, you see, it's a way of couching it. To me, the people will not understand how far-reaching this act is. It is not just about the no confidence motion. It goes much further. This act is passed, and you can have the same situation occurring in St. Lucia as regards the right to remove the Privy Council without a referendum, without a two-thirds majority, and other things like that. And I think it is too far-reaching with respect that this should be done in this manner, read 3 times in one sitting, a bill that was just introduced. The Honourable Leader of the Opposition has not had a time to look at it. We only got it for 2 days. I have not had a chance to properly look at it. The public never heard about this act before maybe last night or today. So it is too far-reaching. This is not just about no confidence motion. And not only that, some of the provisions of the act itself are worrisome. And I therefore think that all we were asking here is that the public be given more time. Don't rush it through in one debate. If it will pass, because you have the majority, maybe it will pass. But give the public a chance, we are requesting, to look at it, especially as it concerns the right of appeal to the Privy Council and all those issues. If you refer to that case in St. Lucia, that is what happened. And this is our concern with respect, Honourable Speaker. Just give us time. That's all. And give the opposition leader time.
Mr. Speaker, this bill doesn't say anything about taking away the power of the Privy Council. This bill doesn't say anything about that. This big, Mr. Speaker, the honorable senator must stop this scaremongering. Mr. Speaker.
St. Lucia.
In St. Lucia, the Constitution in St. Lucia and the Constitution in St. Vincent and the Grenadines is identical in relation to the matter as far as the Privy Council is concerned. There's always been a debate that there has been the way it is written in the Constitution, you can make the argument that you needed to go to a referendum, or to go that way the Constitution is written, and to supply a missing word, or to change the interpretation on what persons had hitherto thought. The Court of Appeal ruled, they're not changing the Constitution, that in respect of that matter, you do not have to go to a referendum, but you have to come in the normal way to get a two-thirds majority in the House. But I don't need this for that purpose, because the Court of Appeal has already ruled that in St. Lucia, and that decision is on us, will be binding. Though you can go and challenge it to the Privy Council, it doesn't stop you. It doesn't stop you. It doesn't stop you. Mr. Speaker, the point I was making, so that's dealing with one. Please, stop the incessant chatter and just listen. Please. It's a serious matter.
I agree it is serious. So when you...
But just stop the incessant chatter. I am on my feet. Stop your incessant chatter.
You do the same.
Grow up now. Grow up.
Yes, I'm a child. I will protect the rights of the people of St. Vincent and the Grenadines. You cannot change a constitution that way.
But we are not changing the constitution.
But that's what will be the result. We just need time.
What kind of foolishness is this?
Honorable member, honorable senator, are you saying that the decision by the Court of Appeal on the St. Lucia reference is unconstitutional?
I am saying that what it does, it changes the need for a referendum.
I heard what you said. I heard that clearly.
The people of St. Vincent have a right to understand that if this reference act is passed, that same situation can obtain.
But honorable member, would you agree that the decision of the Court of Appeal, of our Court of Appeal on the St. Lucia reference, that decision is binding on St. Vincent and the Grenadines?
It may be binding.
What do you mean may?
I say it may be binding.
What do you mean may?
Because the people have the final authority, the final power. That's why I think the people need to understand that this can impact. That it can impact.
Honorable Senator, you have been practicing law for a long time. Now, if the Court of Appeal make a decision and it's an OECS court, and that decision is a part of the body of laws in the OECS, what do you mean when you say the decision may be binding?
Because it has not been challenged. And it can be challenged.
No.
And that's what I mean, that it has not been challenged.
No.
And we need a chance to challenge it.
If a law...
Well, it is only binding until it's challenged.
If a law is not challenged, is it not the law?
I am saying, but the opportunity for challenging it is there. That's what you asked.
But further than that, do you, because you referenced the St. Lucia thing, is it not true that even if you were to take the route, take the interpretation as offered by the Court of Appeal, is it still not true that in order to go from the Privy Council to, let's say, the CCJ, is it still not true that the court ruled that you would need 2/3 majority of the parliament to do it?
What the court ruled is that you wouldn't need a referendum. And that is how St. Vincent has always known it. That is why I think the Constitutional Provisions Act was not voted upon, was not agreed upon, because of the need. I think Vincentians want their referendum, or give us a chance at least to explore it. You have the majority. Once it is debated, the Bar Association understands it, and the public knows about it, then come and debate it. What is the rush? That's all I'm saying.
I don't think the question here is a question of rush, because I haven't gotten an indication from the leader of the House that the suggestion which is coming from this side may be shut down. But I think the question which the Prime Minister...
Well, if it will not be shut down...
No, I'm saying, but what I think the Prime Minister is referring to is when you give the impression that this act may allow for this and may allow for that, when we know, and you as a lawyer more than anyone else in St. Vincent knows, that there's a law binding on countries in the OECS with this particular section in the Constitution that allows for us not to go to a referendum.
St. Vincent, St. Lucia.
St. Vincent and St. Lucia. So it seems to me that to raise that point in the parliament now is to give the impression as though this act would do something that cannot be done with the present legal construct.
Mr. Speaker, that is only in relation to one point. The act itself leapfrogs. It goes straight to the Court of Appeal. We never had that before. You normally go through the High Court and then to the Court of Appeal. So I don't want to go into all the different areas to debate. I'm just saying, I just mentioned the Constitution as one point. But leapfrogging directly to the Court of Appeal is something new also. Why don't we give the citizens a chance to study it, debate it, and then we come back to the House? Especially, as I said, we only got it for 2 days. That wasn't the only provision.
Speaker,
there are several other provisions.
Mr. Speaker, I would wish to open the debate, and I would agree that we can agree that the debate could be continued. I would add, so that when this is being discussed in the public would have heard the views of this side of the House, so that we could avoid all kinds of misrepresentations. I don't want that.
Mr. Speaker, I want to say that I think the proposal by the Honourable Prime Minister is acceptable to us, that he lays out the framework this evening, that the public is then more informed, and then he suspends the discussion to an appropriate time, and we take it from there. Pretty much in the same way, not quite the same as we did for the resilience levy that we just had, because time is not of the essence in the matter, clearly.
Mr. Speaker, are you happy with this? Sure. Thanks. Mr. Speaker, the object and reason of this bill is to make provision for constitutional and other questions to be referred to the Court of Appeal by the Attorney General. There is an identical law in St. Lucia, which is within the four walls of the Constitution of St. Lucia, as in fact this is. In the United Kingdom, a reference is made, Mr. Speaker, to the Court of Appeal. The reference doesn't have to be made to the High Court. The reference is made to the Court of Appeal. When a question arises which it would be sensible in all the circumstances to have the Court of Appeal reflect on the issue and to say that the questions which are asked by the Attorney General in terms of the interpretation of those particular issue in the Constitution, what is the view of the Court of Appeal? It's the opinion of the Court of Appeal. It does not prevent a litigant, Mr. Speaker, from approaching the High Court, you know. But when you go to the High Court, there is an opinion of the Court of Appeal. You can take any factual situation to the High Court. A litigant can say, okay, the Court of Appeal had given that particular opinion, but the facts which we are presenting were not on all fours with the questions which were posed, Mr. Speaker, on which the court has rendered an opinion. But if it is a question upon which the court has rendered an opinion, having gone to the High Court, the High Court would say, well, this Court of Appeal decision is binding. They will follow it. It goes to the Court of Appeal. The Court of Appeal may reflect on it further, agree with their original constitutional interpretation or not, and then you can go to the Privy Council. It doesn't, Mr. Speaker, take away any right to go to the Privy Council. What it does, it takes an issue which could be fraught with all sorts of political ramifications and take it away first from a contested position between litigants to have the Honorable Attorney General say there are problems with this issue in terms of interpretation. I would like to ask the following half a dozen questions, and would you please give answers to these questions? That's what it says. But it doesn't prevent a litigant to go to the court, to move the High Court in whatever way it wants to move the High Court under the existing rules of the High Court and the law in relation to the High Court. It doesn't change the constitutional redress rules for litigants before the High Court. Does not, absolutely does not. It doesn't say it. It doesn't repeal the constitutional redress rules which are in this book. It asks for the opinion of the Court of Appeal on the following questions of interpretation. And if I go through the sections, Mr. Speaker, and Mr. Speaker, you are an experienced lawyer. These are matters the Attorney General may consider in relation to the Constitution or any law that is passed. Is this law unconstitutional? Let's ask the quota number question, the Court of Appeal, to guide us.
Is there a case where the Attorney General, the matter is before the court?
No. If there's a matter before the court, it takes its normal course. It takes its normal course. Okay? And Mr. Speaker, if you look at the savings section under clause 9, the provisions of this act do not derogate from the powers of the court under any other enactment. It's very clear. It doesn't derogate. Mr. Speaker, let us go through the sections for the public. Clause 3, referring questions for opinion. The Attorney General may, with the approval of Cabinet, refer to the court for hearing and consideration any important question of law or fact concerning A, the interpretation of the Constitution, B, the constitutionality or interpretation of any legislation enacted by Parliament, and C, any matter which, in the opinion of the court, justem generis, with the matters contained in paragraphs A and B submitted by the Attorney General as an important question. Notice, interpretation of the Constitution, the constitutionality or interpretation of any legislation enacted by Parliament, and any other matter which, in the opinion of the court, connects to and is within A and B. Questions deemed important. It's a matter deemed important. A question concerning any matter mentioned in Section 3 and referred to the court by the Attorney General shall be considered to be a question of public interest or public importance. Incidentally, the Christian Council, in their comment, Mr. Speaker, said that they like the idea of we bringing a law like this and have it go to the Court of Appeal. You may recall that in their public statement. The Christian Council didn't say this. See this. I'm saying that the Christian Council is making the report on the discussion which took place in the Parliament on the motion of no confidence. Question deemed important. I've just dealt with that. Clause 5, opinion of the court. Where a reference is made to the court under Section 3, the court shall A, hear and consider the reference, B, answer each question so referred, C, certify to the Attorney General its opinion on each question with reasons for each answer. Mr. Speaker, the opinion of the court does not emphatically prevent a litigant on any matter on which he or she feels aggrieved to go to the High Court. This doesn't oust. This is for an opinion to guide public policy, to guide people in the country. This is what the opinion on this controversial question, whatever that legal question may be. Notice to interested persons. The court has power to direct that any person interested, or where there is a class of persons interested, any one or more persons as the representatives of that class shall be notified of the hearing on a reference under this act, and those persons are entitled to be heard thereon, whether in person or by counsel acting on behalf of that person. So, Mr. Speaker, if a matter is brought before the court, and on the face of the questions being asked, the court can say, well, we need to say to John Brown, we need to give them a notice. Or, if they don't say that, they say, well, a particular class of persons may be affected by this. It may be something dealing with taxation. They may say, well, the levy which we have just passed, if that is to be referred as if it's constitutional or not, and nobody will challenge it, but I'm giving by way of an example because it's clearly constitutional. The point would be, you would ask the Tourism Association. You would ask for interested persons to come before the court. Then clause 7. The court may, in its discretion, request any counsel to argue the case with respect to an interest that is affected, and provided that which has not been instructed by an interested person. So the court, If you don't go and get a counsel for yourself, the court can say, look, you can get John Brown, you can get XYZ QC. And then, costs and expenses. Clause 8. The court shall make an order as to costs, shall not make an order as to costs. Unless for exceptional reasons the court considers it proper to do so. Clause 2, subclause 2. The court may, in its discretion, make an order that the expenses incurred for a matter heard under this act may be paid by the Ministry of Finance and shall be a charge on the consolidated fund. So that there's an interested party, Mr. Speaker. The interested party say, well, you know, I don't have any money to hire a lawyer. The Attorney General referred this thing. The Court of Appeal would say, well, you know, in these circumstances, we will get a lawyer competent in this subject area. And then the court, obviously the lawyer has to be paid. And the person who, the entity which will have to pay is the Ministry of Finance. And the court may well order that. And I go back to clause 9, Mr. Speaker. This bill doesn't derogate. The provisions of this act do not derogate from the powers of the court under any other enactment. So, I am puzzled to find that this should be a controversial matter. All this is doing is to seek clarity on a range of matters possible. You're not going to have an Attorney General reference every Monday morning. That doesn't happen with Attorney General's references. That's not the history of them. And the Court of Appeal is the body which has the discretion all the time in dealing with this matter. And take the question out of the hurly-burly of confusion and to determine the matter judicially. And that is it. And Mr. Speaker, the question which prompted this is the motion of no confidence. And we had a long debate on that provision, Mr. Speaker. And you yourself said it's a matter on which you said it then and you have said it subsequently, that you think it's a matter on which there should be clarity. You said it in a subsequent meeting. And that's not the only question. I just mentioned one. The public is exercised about whether Godwin Friday, Dr. Godwin Friday. I'm just saying this. The question, I don't know whether the Attorney General is going to say, well, it might be better for him to do that than to have John Brown from the Grenadines challenge him, and you have a lot of political confusion on that. But have it, in a sense, done in a more independent and, I wouldn't say sterile, because the law is never really sterile in that way. It is an alive issue always, and it generates controversy in an objective way. You see, this is the point. What does Mr. Straker, the Honorable Louis Straker, has to do with this? The Honorable Louis Straker renounces American citizenship. He did it. And Mr. Speaker, this brings me, since there's that crosstalk, I just want to say this. I want to draw attention to the Honorable House. There's something, and I think Madam Clerk could take note of this, and you, Mr. Speaker. Section 62 of the Representation of the People Act. And I'm outside now of my presentation specifically on the bill before us. Something which has not been done since I'm in this Parliament in 1994. Section 62 reads, members to make declaration of qualification and take oath of allegiance every person elected as a member of the House of Assembly shall, before sitting or voting therein, make the declaration of qualification in Form A and take and sign the oath of allegiance in Form B. I can't recall that we have done a declaration of qualification. Never. And the Honorable Clerk, and I suspect the Honorable Clerk has just indicated, Mr. Speaker, she had never done that, because I believe what happens prior, and this could be checked, prior to the Representation of the People Act, more than likely there was not such a provision. I haven't had a chance to research that. So that we have been doing it as we have been doing it since statehood to the early days of independence, because this was done in 1982. So, Mr. Speaker, inasmuch as the Honorable Senator Bacchus Batiste has raised the question, I want to suggest that since we haven't done this at the beginning, it doesn't invalidate any decisions which we take here, Mr. Speaker, because the body of the law makes that plain. We should all, at the next sitting, I want to suggest this, that every person elected as a member of the House of Assembly shall, before sitting and voting therein, make the declaration in Form A and take and sign the oath of allegiance in Form B. This deals with the Representation of the People Act, and it deals with representatives. But I would expect the same would apply on the basis of the same reasoning by senators. And I think we should do it. Yes, I think we should do it. It didn't say nominated, but I'm saying by the same reasoning. By the same reasoning. Yes. Elected. The honorable member, the honorable senator is quite correct. I'm reading just the law. It says elected. But I'm saying by the same reasoning. So that I am sure the Honorable Sir Louis Straker would be prepared to sign that he's qualified, as indeed I am. And I think everybody will do it, and I suspect that the Honorable Dr. Friday would also do it. It's an important oath to be taken. So I believe that we should put it right. It doesn't invalidate anything which we have done here. Mr. Speaker, that outline which I've just done here on the bill, so that the public will see there is nothing, no hidden agenda in this bill. In fact, the only instruction I gave to the Honorable Attorney General, could you please get the bill, the act from St. Lucia, and let us bring the same act. That's all. He got it. And we bring it. And as you see, there is a safeguard at every step. And I want to repeat, this bill does not oust anyone, any litigant, from going to the court, the High Court, and bring a matter, Mr. Speaker, a factual matter, upon which the Court of Appeal has pronounced and given an opinion. But of course, if they give an opinion in a legal sense, as they would, a legal opinion, the High Court will say, well, I am following the opinion of the Court of Appeal. And it goes to the Court of Appeal. The Court of Appeal may, on the facts which are now before them, say, well, I gave this opinion, but the question which arises here now is a slightly different question than the one the Attorney General has posed. So this is our view. And you go to the Privy Council also. And that is the long and short of this bill. Mr. Speaker, I don't know if you think that I've covered it adequately.
I would think so.
And if there's any...
I don't know if any other posted...
I don't want to have any confusion, and to emphatically say the application of the ruling in St. Lucia to St. Vincent on the Privy Council issue, you will require a 2/3 majority of the House. No. The question is now a different question, a political question. The Parliament may determine by a 2/3 majority whether you stay with the Privy Council or not. But having gone to a referendum, the question that will have to occupy parliamentarians' attention, though it was one question among many, whether the public would want you just in the Parliament to do it, it having been done by a referendum. But that's a political question. That is not a legal question. That's a political question. Honourable Member from Central Kingston, you grasp the point I'm saying? That's a political question. That's not a legal question.
That's why I asked before.
Okay? So that, and I think that I have covered all the bases on this issue. And when the next time we meet, other members will have an opportunity to speak, and I will certainly have an opportunity to wind up. And as the discussion goes, we will have more amplification. Somebody from St. Lucia can be brought here to speak about it and what has been their experience. Let us conduct this matter in a manner which is mature and where
Campbell, please don't say nothing about it.
and reflecting it.
Because you can just muddy up the water.
Reflecting it in a manner which doesn't add to any confusion. Mr. Speaker, as I'm finishing, in relation to the issue what has been raised, I think that we should comply with the law. And I think on the next occasion, the Honourable Clerk should have the matter here for all elected representatives, and let us sign the Form A. And let us sign the Form A. The question could be looked at as to whether there's a requisite for the signing of it by senators, but certainly by representatives. This would be my own recommendation in that regard. And I think, Mr. Speaker, it's unanswerable, really.
If there had been an omission on the law, then if there had been an omission on the law, then we have to comply.
We have to correct it. Section 62, we'll just have to correct it. Mr. Speaker, that is... You mean...
have the vote of no confidence debate.
Well, I don't...
That's it, we don't know.
I don't know what the Court of Appeal will say if the Honourable Attorney General comes and says he wants to make that reference. He has to initiate it.
Oh, you don't know if he's done that?
He has to initiate it. You know, I don't know. I will tell you something.
You're smiling.
I will tell you something. One of the reasons since 2001 that we have not taken the option of appointing a political Attorney General, either a representative or a senator, is because in our small societies, it is good to have the post of the Attorney General insulated from that kind of a political rough and tumble and tug of war. And he is, no. But it first of all has to come from the Honorable Attorney General. It's not the Prime Minister's reference, you know. But you don't understand. I mean, it's difficult to give a 101 law 101 seminar in a few minutes. You know, it's really difficult. Mr. Speaker, I
would suspend.
So I will suspend. In any case, Mr. Speaker, where the time is 10 to 7, if even we were to have this debate, it's unlikely that persons would be listening. They would go to the news shortly, and after the news, it would be bold and beautiful and something else. And we will talk among ourselves. Or whatever is the popular show. I mean, that's called House of the Prairies. So that's... Mr. Speaker, I don't know, therefore, if you want me to suggest a date for the suspension, or you wish to say something on this before I move.
No, Prime Minister, well, Honorable Leader of the House, I don't need to say anything on that point.
Mr. Speaker, I'm suggesting the 24th.
So we're gonna put over the church bills as well?
Oh no, we'll do the other things, Mr. Speaker, but afterwards I'll suggest the 24th of May. Yeah, small things. I'm obliged, Mr. Speaker.